the British Supreme Court was on the news recently,
Yes.
even here, because of the definition of woman.
Yes.
So, though I promise to be lenient, it has to be the first question. Given the court's unanimous decision that Women in the Equality Act refers to biological sex and the wider public debate around gender identity, how does the court weigh the potential social impact of a ruling like this, especially when the legal definition might not align with how some people experience their lives? Do you worry that this judgment could be used more broadly to justify exclusionary behavior that goes beyond what the law actually says?
No. We as judges have a very specific task to interpret legislation in good faith, according to the law. It's not our function to make social policy. So in this case, we were interpreting particular legislation. When we looked at the legislation, the text only made sense if you interpreted the term woman as meaning a biological woman. Let me give you one example. There were provisions requiring employers to take special measures for the protection of women in relation to pregnancy, maternity, and other conditions specific to women. Now, if the category women could include biological males, and if it did not include all biological women, then there was no such thing as a condition specific to women. For example, on that definition, women could contract prostate cancer. Men could contract ovarian cancer. So an interpretation of the word woman, which included non-biological women, simply made no sense. So it was clear what Parliament had intended when it enacted the legislation in 2010. So we interpret it according to what the text says. The reaction, of course, has been very mixed, but for those who are unhappy with the result, my message is, don't shoot the messenger. If you are unhappy with the law enacted by Parliament, then you can campaign for a change in the law, and that's the appropriate response if you are unhappy, not to attack the judges who have interpreted the law according to what it says.
Yes, so I think we are clear on that the court's job is to interpret the law. But your decisions inevitably shape public attitudes and policy. In this instance, do you think the ruling gives enough legal clarity to stop it being misused, say in debates over access to services or public spaces? Or is it now up to Parliament to step in and tighten things up through legislation?
Well, there is a lively public debate at the moment. Our judgment has resulted in questions because the practice in some sectors was not in accordance with what we have decided it to be. For example, in sport, allowing biological males to compete as women in sports where they have a competitive advantage because of greater strength, for example. So changes are being introduced. We have a statutory body called the Equality and Human Rights Commission, whose function is to issue advice about the implementation of the law, and they are doing that now in the light of our judgment. There will continue to be people who are unhappy with the result, as I say, it is open to them to obviously to argue for the law to be adjusted. I mean, we all acknowledge in the UK that there are people who are vulnerable to harassment and discrimination because they are biological males who have been allowed to transition through medical procedures to acquire a female legal gender for some purposes, but not for all.
Okay, there is another topic that I'm very much interested in, and it's the fallout from Brexit.
Yes.
Since leaving the EU, how has Brexit actually changed the day-to-day work of the UK courts? And think about things like now, like how you approach legal interpretation,
Yeah.
which precedents carry weight,
Yeah.
and how powers are divided between the judiciary and parliament. Would you say it's made the judiciary more independent, or has it opened up fresh constitutional questions?
The constitutional questions that have arisen have not really concerned the judiciary. They've been a result of the repatriation of powers from Brussels to the UK. In the UK, we have a system where some functions are exercised centrally by the UK government and others by regional governments, which have devolved powers, rather like in Spain, for example. And there's been a struggle, if you like, over who should get the powers that came back from Brussels. So far as the courts are concerned, the main difference is that we can no longer refer questions of interpretation of EU law to the European Court of Justice in Luxembourg. As a result of Brexit, a great deal of our law came from the EU, but it was converted into domestic UK law overnight, and we now have to interpret it. But a lot of it is not of a conventional British form. It's drafted in very broad language. The Luxembourg court would formally have interpreted it in the light of submissions by the member states and the EU Commission, and would have adopted a broad policy-based interpretation. We can't follow that methodology, and so we are adopting a narrower, more text-based approach, and it sometimes causes us difficulty, just as a matter of applying legal techniques.
With the ICC's recent move to seek arrest warrants for both Israeli and Hamas leaders, spotlights back on international justice. But when some countries reject the court's authority outright, and others only follow the rules when they suit them, can the system really function properly? And do you see a role for national courts in helping to uphold or align with international law in this kind of fractured global landscape?
Well, I think, speaking in general terms, national courts can play an important role when the relevant international law has been given effect in the domestic legal order. I'll give you two examples. General Pinochet was arrested in the UK.
I remember very well.
You remember that. He was arrested because we had given effect in our national law to, he was arrested, in fact, on a warrant issued by the Spanish courts. And we had an agreement with Spain to extradite people who were wanted there. So, so that's one example. One we had more recently was, you may remember the dictator in Liberia, Charles Taylor. His wife was living in the UK, and she was charged with offences against of torture against the UN Torture Convention. And we were able to deal with that case and authorize her arrest in the UK because the Torture Convention had been given effect in our law. So provided there is a domestic hook to hang international law on, we will give effect to it.
Okay, more or less in the same area. Given the stark imbalances in global power, how weak enforcement often is, would you say global justice is a real working concept at the moment? And if so, what would you need? How would it need to change legally, institutionally, for it to become more fair, credible, and effective?
That's a very big question. Are you talking about justice in terms of the law rather than social justice?
Right, yes, well.
There's not much I can do about social justice, I'm afraid.
I know.
When it comes to legal matters, we, on my court, well, first of all, as a country, the UK, like many other countries, tries to promote international cooperation in legal matters. So, for example, to combat money laundering or illegal migration, or to work more effectively in areas like family law, where there are more families with people from different countries than there used to be. There has to be cooperation between different countries and cooperation between their courts, which often depends on mutual trust. We have confidence in another country's courts to be honest, to be reasonably efficient, to be politically independent. And so we work a great deal with other courts, for example, in those of the Dominican Republic and elsewhere in the Caribbean, to get to know each other better, to be able to assess whether courts are honest and efficient and independent, and where they are, to put in place arrangements for cooperation between ourselves.
Okay. Well, this is a topic that you know very, very well, is independence and executive power.
Yes.
In a time when governments seem more assertive and centralized, how do you see the role of judiciary in keeping that balance between branches of power without crossing the line into making policy?
As you say, it's important that we don't cross the line into making policy. And so we need to, in cases, obviously there are cases that come before us where governmental decisions are challenged, or where you have a constitution, as in this country, where legislation may be challenged. And courts have to give appropriate weight to the judgments made by those who have a democratic mandate to make judgments about social policy, which courts don't have. But we also have to be courageous when the need arises to defend the Constitution, to defend the rights of minorities when that may be unpopular, to defend the rights of individuals. For example, in my country, during the Brexit period, we had quite a difficult case to do with the government effectively suspending the operation of Parliament for a time, because they might have encountered difficulty in getting their proposals approved. And we had to decide that Parliament was the supreme authority in our country, and it was not a matter simply for the government to decide when Parliament sat and to suspend it for as long as it pleased, which was the argument being advanced. was a very controversial decision, of course, but we needed to have the courage to make it and live with the consequences. I think you need, at the highest level of the judiciary, you need to have judges who have a very good antennae to be able to judge where the boundaries lie. And I think it's also, I mean, I have found it's important both to engage with the media so that they have as good an understanding as we can help them to have of what our role is, but also to engage with parliamentarians so that they understand what the constitutional role of the court is, and that the democratic mandate of the government is not a blank check, that there are constitutional limits which the courts have to apply.
Yes. Just a final question. You know that society changes, new values, morals, and so on and so on. How should courts deal with that? Should judges try to interpret the law in a more forward-thinking way to keep up? Or should they hold back and leave change to Parliament?
Well, I think the answer may depend to some extent on the particular legal tradition. But in our tradition, the courts certainly have a role in keeping the law up to date. We have what's called a common law system. It's traditionally dated to the year 1189. It's not the same today as it was in 1189, and that's because judges are constantly developing it. Currently, under our understanding of the Constitution, we would leave major changes to Parliament. The big steps are for Parliament, but we will make more modest adjustments all the time. For example, my court took an important decision recently to require in medical treatment that doctors obtain the informed consent of their patients. That's a legal requirement, whereas previously it had been considered that it was a matter of simply medical judgment, how much information a patient should be given. Now, that was a legal change that we made in response to our feeling that in today's society, patients expect to be more involved in decisions about their own treatment, and the paternalistic idea of the doctor knowing best had become outdated, although it might have been appropriate 50 or 60 years ago. And that decision didn't excite any controversy. You know, it reflected what most people believed. On the other hand, we had a case where we were being asked to find that there was a right to assisted suicide for people who were suffering severe illnesses. And that is, and was at the time, a very controversial subject. To say that for one person to help somebody else to kill themselves was no longer a criminal offence would have been a major change in our law, for which there wasn't a general consensus of support. So we said, no, that is a matter that we would leave to Parliament. So we make a judgment really about how dramatic a change is involved. There was one of my predecessors. I don't know if you're familiar with cricket.
Yes.
Right. Well, one of my predecessors said that the common law scores its runs in singles, and we don't hit sixes. Which is a good way of putting it.
Yeah, right. Thanks very much, Mr. President.
Thanks, sir.
It's been a pleasure.
Thank you.